8 Steps to Suing a Debt Collector. Brought to you by YourLegalLegUp.com, your advantage if you are being sued by debt collectors. Here are some steps to follow if you are being harassed for debt and want to sue the debt collector, or if you believe the debt collector has violated your legal rights in other ways and you feel a suit is justified. This isn't intended as legal advice, but rather as one type of analysis you should consider as you make your decision. Lawsuits are serious things, and it isn't always possible to control what they become. We illustrate that every time we talk about a counterclaim, right? That's a perfect example of lawsuits leaving the control of the person starting them. Step 1. Figure out the status of the person harassing you. Is it a debt collector, or is it an original creditor? That's a vitally important first distinction, as it will go a long way towards just determining what your rights are against them. Generally speaking, the original creditor is the person who claims that you owe it money because of some transaction that occurred between you and it. For example, a utility company might sue you for unpaid bills, or a credit card company itself, not a company it sold the debt to, could sue you or could be harassing you in other ways. On loans, the term original creditor also includes the loan servicer. That would be a company that took over the loan while your payments were current and has managed things from there. Debt collectors are companies that either work for the original creditor but don't have the same owners. That is, they can't be the same company. Or who buy the debt after it is in default, junk debt buyers. We often refer to them as vultures. Your rights against a debt collector are much more extensive than they are against original creditors, starting with the FDCPA, but also including many state statutes that could add to your rights. Step 2. What is the action that you consider illegal? What do you think they did wrong? Something specific that they did that was illegal, or that they failed to do that was required by law. Remember that you can't successfully sue someone simply for annoying you. The point of a civil lawsuit is to seek relief, that's usually money, for some illegal act or acts. A major source of rights against debt collectors is the FDCPA, the Fair Debt Collection Practices Act. We've got a lot of material on this law, obviously. If the action in question, for example, is repeated telephone calls at 9:30 at night, that will probably be a violation of the FDCPA if it's done by a debt collector. Although it might not be illegal for the original creditor unless you can find a state law that makes it illegal. In most situations, the FDCPA does not apply, as we said, to the original creditor, although there are some instances where it does. On the other hand, a threat to set your home on fire if you don't pay a bill is likely to be illegal for both the original creditor as well as debt collectors. There are some limits, in other words, although they can be pretty extreme. You can Google the action, your state's name, and the word illegal and get a feel for whether the action is actually illegal. Even original creditors have some limits, and sometimes they can be subject to the FDCPA, as we said, if they're pretending to be a third-party debt collector, for example. Or you can do a more systematic search at a local legal library, as I explain how to do in our materials. Step 3. Consider legal representation. Under certain circumstances, this might be a step 1, but I am assuming a certain self-reliance and a normal reluctance to contact lawyers if you're watching this video. If it looks like you might have a legal action, you should consider obtaining legal counsel. It usually doesn't cost anything to talk with a lawyer to see if he or she sees a case and is interested in representing you. The FDCPA includes a right to attorney's fees if you defeat a debt collector, and other laws, while not always including a right to fees, might be attractive enough to a lawyer for him or her to take the case on contingency, meaning to take their money only if they win at the end. Lawyers often do want some money up front, though. Step 4. Assuming you're going to do this without hiring a lawyer, and that you feel you have a right to sue, you will now want to do some more legal research. Check out our videos on legal research and do some research on the specific actions you're complaining about. You want to make sure what the laws are that were broken and what you need to prove in order to get your remedy. It also helps to know what the remedy is in court if you know, what it could be if you win. How much money, in other words. Step 5, choose your jurisdiction. If you want to sue someone under the FDCPA, you could bring your case in federal district court or a state court. If the action is simply under a state law, you'll likely be limited to state courts. But they're not really rustic or unsophisticated. State courts are pretty good places to bring lawsuits these days. You'll have to consider which court to bring your case in. You can get help on that in our materials, along with lots of other help, of course. Step 6, draft your complaint or petition. Again, how to do this is beyond the scope of this video, but you'll find help in our materials if you join us, or you can either go look at pleadings filed in your court or Google cases like yours. Step 7, file your petition and obtain or write, depending on what the court clerk tells you to do, a summons. Your petition is your statement of facts in law. It comes from you officially, but the summons is actually officially from the court. You may have to name the corporation and its agent for accepting service in your petition, and probably in the summons, and you'll need to know it for serving the case anyway. Finding the agent is free and easy. You can get these things from the Secretary of State for your state. Either call the Secretary of State's office, probably in your state's capital city, or go to its website. Look up the company and get its official name. That's who you will sue if you're suing the company. And the person designated as agent for receiving service. That's who will be served the lawsuit physically by the process server. Most states require businesses to give the address of a person who will accept service if the company is sued. Step 8, serve the lawsuit on the company. Look up in the rules of civil procedure for your jurisdiction or the local rules for your court for who must serve the suit. Usually this will be an adult non-party to the suit. Some courts, however, require that the suit be served by a sheriff. Others require it to be done by a private certified process server. So you got to find out what the rules are for serving process in your jurisdiction. They vary. If you must get a private process server, call a private detective firm or look up process server in the yellow pages or Google it. They aren't expensive. $25 to $50 usually gets it done. Find the right process server and get the suit served on the registered agent. This is actually quite easy. You are now suing the debt collector, and at this stage you're going to need to do the things that will help you win. We have materials on that, obviously. Give them a heck. Defend yourself from the debt collectors. Don't let them rip you off. Please like this video, comment, and share it with others, as these things help other people find our materials. yourlegallagup.com